thank you very much, everybody, for coming. I'm glad to see we have some new faces, and want to welcome y'all. We do this every Friday, 7:30 Pacific time, so you're more than welcome. I know Steve likes to say you're now a member of ICUJP, but
Card carrying.
yes, the card carrying member of ICJP. So feel free to come back anytime you'd like. And we wanted to do actually introductions. So just a brief statement about who you are and any affiliation you have with any organizations and anything like that. There is our Instagram, our Facebook, our Twitter, and our main page. If you use any of those, feel free to become a partner of ICUJP or click like on any of our pages and you'll get information. You also get neat pictures. Some people post vacation pictures, which are always interesting. But on the ICUJP page, there is a donate section. And that helps us with being able to put on these events like the Regus Awards and other and other events during the year. So if you can go on there and make a donation, you can even make a recurring donation. That helps us out a lot. We really appreciate it. Now we have a reflection from Mr. Rohde. So if you'd like to go ahead, that'd be great.
Thanks. I should have alerted you, Rick. I'm combining my reflection with my talk today, since they would have overlapped significantly in all events. So I will launch into that. I'm so pleased with everyone who's joined us today. Yesterday constituted the end of the 2021-22 term of the United States Supreme Court. And in this interfaith setting, I can say, thank God the term came to an end. The mischief, the dangers that this Supreme Court has engaged in, and the predictions of future dismantling of American institutions is no exaggeration. We're about to celebrate July 4th. Many years I've used this. In fact, I signed up to have a reflection today a couple months ago because I've often given a reflection in or around July 4th, but I do it by quoting Frederick Douglass's famous July 4th remarks. I'm not going to dwell on that today because we have so much else to cover, but I do hope you'll look up Frederick Douglass's remarkable comments that essentially, paraphrasing his opening, what is to a slave the 4th of July? And it's another sober effort to take a hard look at American exceptionalism, at the way we celebrate events like the 4th of July in such a unabashedly super patriotic fashion, while ignoring the hypocrisy of the Declaration of Independence in supposedly announcing that all persons are equal. So there's a lot to think about in and around the 4th of July. There'll be all kinds of celebrations and fireworks across the country. I never diminish the opportunity for friends and family to get together on occasions like this. But as our wonderful member, Chris Panett, coined decades ago, we have to exercise resistance at the water cooler. What he meant by that is the water cooler is the quintessential meeting place in the workplace. I don't even know if there are enough water coolers still in America, given bottled water and all our other sources. But that was the place on Monday mornings, usually when people gathered to exchange news and recollections. And what I think Chris was getting at is that we have to think of every setting in which we find ourselves, the workplace, family occasions, dinners, and other settings, to try to speak truth to power, to shake people out of their complacency, and to wake them up to what is happening in the United States of America. And the part of that that I'll be focusing on today is the United States Supreme Court. Most of you know that until I retired, a large portion of my law practice was constitutional law. And I took pride in analyzing and thinking about the United States Constitution and the periods in American history when the Supreme Court was at its best, when the Supreme Court, especially in the modern era, led by Earl Warren and an extraordinary Supreme Court Justice, William Brennan, when the court saw its role as lifting up individual rights and constitutional liberties, when it saw its role as expanding and guaranteeing and protecting those rights. But the Supreme Court has also had some very dark chapters in American history, and it began with that very US Constitution. The US Constitution is a deeply flawed founding document for this country, and no one should celebrate it in any kind of blind adulation. The United States Constitution institutionalized human bondage. It declared that enslaved people were 2/3 of a white citizen. There's all kinds of politics behind that clause, and you can look that up and study it. It doesn't take away from the fact that that clause is in our founding document. The US Constitution for 20 years in our Constitution protected the importation of human beings as enslaved people. And it had other terms and clauses which protected the original sin of America in the name of the institution of slavery. It was a shameful document in those respects. But somehow, in the midst of that, and in the first 10 amendments to the Constitution, which we call the Bill of Rights, and then the subsequent post-Civil War amendments, the 13th, 14th, and 15th Amendments, the Constitution is kind of a young freedom fighter struggling to throw off the bonds that encased these essential ideals within this ignoble document. And I think in a way that's a metaphor for the United States struggling to throw off the legacy of slavery, the legacy of despoiling and eradicating Native Americans, the struggle to give women equal rights, and the struggle of other minorities and groups that were outside of the white Christian establishment, some measure of the equality that this document promised. So in my constitutional law practice and doing civil rights law and writing about it and working with organizations like this one and the ACLU and Death Penalty Focus and others, it's been my goal to breathe life into that Constitution because I do see it as a living document, as a document subject to change to meet ever new circumstances. And at the very core of what has happened in this season's Supreme Court term, it is a head-on battle between what a group of conservatives call originalism versus this notion of a living constitution. William Brennan, who I'm so grateful I got to meet in his chambers at the United States Supreme Court shortly before he passed away. It's one of the most vivid memories I have in my life of being with my sister Elaine and my wife Wendy, shaking his hand, a frail man at that point in his life, a exemplar of the US Constitution framed behind him at his desk. It was an extraordinary moment for me. William Brennan warned that originalism is arrogance cloaked in humility. Arrogance cloaked in humility. Originalism is a facile theory of the Constitution that today we are bound by the intentions of the ratifiers of the US Constitution, the men who wrote, approved, and ratified the Constitution, and then the men who wrote the 14th Amendment in 1868. Originalism traps the Constitution in eras in American history when this country was dominated by white free males. And it is such a convenient doctrine for reactionary conservatives to try to dress up in long law review articles and in court decisions. And we will get to the very meaning of that when we talk about the Dobbs case today, which literally reversed 50 years of constitutional law in reversing Roe v. Wade. Justice Brennan called it arrogance cloaked in humility because those who propose and promote originalism act like their hands are tied. They are just doing the founders' will in limiting rights to the 17th, 18th, and 19th centuries, I should say. And it's arrogance because they know that's not what they are doing. What they are doing is implementing a reactionary, conservative political agenda in the name of their fidelity to the Constitution. So in this term, we have literally seen a super majority of 6 conservative justices, sometimes unable to attract Chief Justice Roberts, so they did their mischief with 5 majority votes. But taken together, and so many of their decisions were 6-3, with Roberts joining the 5, that they have literally rewarded 4 constituencies that make up the far right wing of American politics today. Most recently, they rewarded the pro-business wing of the Republican and conservative party by dismantling the EPA and its environmental restrictions. They have rewarded the anti-abortion wing of this right-wing coalition by overturning Roe v. Wade and the Casey case, and we'll talk about these. They have rewarded the pro-gun NRA wing and constituency of this far-right movement by overturning a century-old gun law in New York State. And they have rewarded the Christian nationalistic wing of this group in at least 2 cases, dismantling the separation of church and state, which was enacted in our First Amendment by those founders. So this project has made this, in my view, and many commentators, of the most radical, transformative, and dangerous term of the United States Supreme Court, perhaps in its entire history, with all of these decisions coming together in a single term. We've had dark and shameful decisions in the United States Supreme Court. We had the Dred Scott case perpetuating slavery. We've had Plessy versus Ferguson creating the distorted doctrine of separate but equal. We had Buck v. Bell allowing the sterilization of women with the legendary Supreme Court Justice Oliver Wendell Holmes Jr. saying that 3 generations of imbeciles is enough, as the court upheld forced sterilization. And we've had the Korematsu case upholding the internment of Japanese Americans, and many other cases I could name. We've had these cases when the court was in the grip of the same kind of cabal of conservative, reactionary judges seeking to stem the tide of justice and freedom that has lurched forward over the history of this country. And we are in the midst of exactly another one of those dark periods on the United States Supreme Court. It is no coincidence that when I list those constituencies, 3 of the supermajority of the Supreme Court are nominees of Donald Trump. Donald Trump did the bidding of each of those constituencies when he and Mitch McConnell forced through those nominations, blocking the nomination of Merrick Garland originally during the Obama administration. Just imagine for a moment if Hillary Clinton had been elected President of the United States, she would have had 3 nominations to the Supreme Court. It would be a 6-3 so-called liberal majority on the court. None of the cases we're talking about today and the other cases in the last 5 years would have ever happened. So I will preview where I will end up by telling you that this is not a dusty law lecture. This is a call to action. And when we get into the discussion phase with each of you, we'll have some opportunity to talk about and answer the question, what are we going to do about this? Let me just try to briefly give you a sense of what this court has done and the breadth of the damage it has caused over the course of this case, of this year. Working in reverse chronological order, as far as climate change is concerned, in West Virginia versus Environmental Protection Agency, which is the EPA, the court in a 6-3 ruling curtailed the EPA's ability to regulate the energy sector, limiting it to measures like emissions controls at individual power plants. The meaning of that case is only being understood as the opinion is being analyzed. And in that case, and every case I'm talking about today, it is the implications not only of the drastic decisions each case already represents, but the analysis, the precedent, and the roadmap that these cases provide for the next session of this court and for future courts, that is particularly ominous. These decisions are a step backwards by any account, but it is in the logic and the theory of these cases and how they can be used by this supermajority in the future that poses such a threat to our constitutional democracy. We had a glimmer of sanity in an immigration decision on June 30, Biden versus Texas, a 5-4 decision where Justices Sotomayor, Kagan, and Breyer were able to gather Justice Roberts and Justice Kavanaugh to make a majority to clear the way for the Biden administration to end a Trump-era immigration program that forced asylum seekers arriving at the southwest border, where Brenda Ringwald is doing such important work, to await approval in Mexico. That was reversed, but only by dint of 2 conservatives jumping ship. We had in Oklahoma versus Castro Huerta a ruling that state authorities may prosecute non-Indians who commit crimes on Indian reservations, seriously undermining Native American sovereignty on their reservations. That was a 5-4 conservative decision because they were not able to get Justice Gorsuch on their side in that case. On June 27, the court further dismantled the separation of church and state in Kennedy versus Bremerton School District in a 6-3 decision, allowing a public school employee who was coach of a football team to routinely convene a prayer session on the football field at the end of football games, in which team members, the record shows, felt obliged to join in a Christian prayer on public property with public money, with a public teacher conducting a prayer, and in a corrupt and factually misleading opinion by Justice Gorsuch, which was so contrary to the record of the case that Justice Sotomayor, in her dissent, had to attach exhibits to the dissenting opinion in order to show that Justice Gorsuch was distorting the record in order to make that decision more palatable to people who are otherwise concerned about separation of church and state. I will save the Dobbs case for further examination in a moment. But on June 23rd, in a 6-3 decision, the court ruled in New York State Rifle and Pistol Association versus Bruin that a decades-old state limit on carrying guns in public violated the Second Amendment to the Constitution. In New York, it's initially illegal to have a handgun. However, for use in your home to defend yourselves, you can apply for a gun permit, and unless there are other grounds to deny it, you get your permit. If you want to carry a concealed pistol in public, all that the law required was you give some reason. That's all this law did to violate the Second Amendment, was to ask for an applicant to carry a concealed weapon in public to give a reason. Are you in a profession? Are you in a dangerous area? Are there reasons, logical, rational reasons you can give? That was too much of a gun safety regulation for this super conservative majority. And they struck down that century-old law that had been applied and used and functioned for almost 100 years. And that was swept away by the conservative bloc. On June 21st, in Carson versus Macon, the court ruled that the state of Maine program that funded schools where in rural counties, and Maine has a majority of rural counties have no public high school, that the state would underwrite other public high schools in different counties to provide for the education of Maine school children. They happen to include private schools. That was the will of their legislature. I'm not sure why the people of Maine wanted to use state money to pay for private schools, but that was the statute. It provided for public high schools and private high schools. But the Supreme Court 6-3 decided that it excluded religious schools from that funding, and with the strike of 6 pens, eliminated that law and requires Maine to fund religious schools. Now, the opinion dressed it up as a terrible effort to discriminate against religion. My friends, the First Amendment discriminates against religion. It is the only provision of the Bill of Rights that selects some part of American society, namely religion, and says that Congress shall make no law establishing religion. It quickly adds, or abridge the free exercise thereof. It was the brilliant compromise in this one instance of the slave-owning founders to recognize the bloody history of European religious wars, to lift up the exercise of religious freedom, but to simultaneously ensure that no state national religion would be established and that no public funds would go to provide support to religion. It was a doctrine that James Madison and Thomas Jefferson worked hard to establish. And this case turns back all of that history, finding a clever and circuitous route to forcing the taxpayers of Maine to underwrite religious schools. I simply want to see if there are other nefarious decisions of this court this season, but my plan today is to focus on the Dobbs case and then to turn this over to this entire group, not only for questions and clarifications and follow-up, but for your own views on these cases and your own experiences and zones of life in which these cases will have real impact. And that, I think, is part of the arrogance of these judges who could sit on high and reverse constitutional rights. Turning to the Dobbs case, this is the case of Dobbs versus Jackson Women's Health Organization. And I want to take several minutes. I've already written about this case. I believe the dissent by Justices Breyer, Sotomayor, and Kagan is one of the most important dissents in the history of the Supreme Court. The role of dissents is pivotal in this court because it has been in these dark periods when courageous judges who could not marshal majorities have spoken out for future generations. They have identified the flaws of the majority opinions, and they have set the stage for a future time when the dissents become the majority opinions. And I think that's exactly what these three courageous justices have done. And it's very appropriate to pause here to thank Justice Stephen Breyer for his service on the United States Supreme Court. He has been a bulwark of this liberal majority. I haven't agreed with everything he's either decided or how he decided some cases, but there's no taking away from his extraordinary work. And I must tell you that one of his dissents was a 56-page um, document of why the death penalty is unconstitutional. And someday, I believe that Breyer opinion, along with Justices Brennan and Thurgood Marshall's opposition to the death penalty, one day that will carry the day. But I do think the only glimmer of a celebration we have today is the swearing in of Justice Ketanji Brown Jackson. And it's so important to pause and take note that today, the liberal wing of the United States Supreme Court is made up of 3 women, an African American, a Hispanic, and a Jew. 3 women hold the minority wing of this court. And I look forward and wish them strength and goodwill and stamina and persistence in the coming years as they continue to confront this super majority of reactionary judges. It was in this 60-page dissent in the Dobbs case, a dissent that is extensively supported by legal case authority. Every proposition in this dissent is well documented. And it confronts the fact that for the first time in the court's history, a constitutional right was taken away. A constitutional right was taken away by the court. Now, the majority said that sometimes we have to correct the court when it came to Plessy versus Ferguson and other decisions, that the doctrine of stare decisis, of standing by precedent, is put aside to correct egregious errors of the court. Well, the truth is that those decisions that reversed Plessy versus Ferguson, Dred Scott, Buck v. Bell, Korematsu, those decisions expanded constitutional freedoms. Commentators and I know of no case in which a long-standing constitutional precedent like Roe v. Wade, which was decided in 1973, going on 50 years, and Planned Parenthood of Southeast Pennsylvania versus Casey in 1992, 30 years ago, reaffirming Roe. I know of no case where stare decisis has been cast aside in order to eliminate a constitutional right. And the dissent points that out. I believe that this dissent deserves to be read by everyone who cares about constitutional democracy. I think it should be required reading for every judge and elected official and voter in America. It should find its place in the curriculum of every middle school and high school and college and university, and frankly, in every home in America, because it sets forth in clear and readable and engaging and compassionate terms not only what the in this case, 5-4 slim majority did, but the implications of it for our entire constitutional system. It's been for half a century that Roe and Casey, the dissent says, have protected the liberty and equality of women. Roe held and Casey reaffirmed that the Constitution safeguards a woman's right to decide for herself whether to bear a child. Roe held and Casey reaffirmed that in the first stages of pregnancy, the government could not make that choice for women. The government could not, I'm watching to be sure I still am on the screen. The government could not control a woman's body or the course of a woman's life. It could not determine what a woman's future would be. Respecting a woman as an autonomous being and granting her full equality meant giving her substantial choice over her most personal and most consequential of all life decisions. Today, the dissent states the court discards all that. It says that from the very moment of fertilization, a woman has no rights to speak of. A state can force her to bring a pregnancy to term, even at the steep personal and familial costs. The Mississippi law barred abortions after 15 months, but under the majority's ruling, a state could ban it after 10 weeks, 5 weeks, 3 weeks, 1 week, or from the moment of fertilization, as several states have already done in the last week. Beyond all this, the dissent warns that the state could impose criminal penalties on abortion providers with lengthy prison sentences, and some states may not stop there. Perhaps in the wake of a decision, a state could criminalize a woman's conduct, incarcerating her or fining her for daring to seek or obtain an abortion. And as Texas recently did, the state can turn neighbor against neighbor, enlisting fellow citizens to root out anyone who tries to get an abortion. Most threatening of all, nothing in this decision prevents the federal government from prohibiting abortion nationwide. And I want to come quickly to what this case previews. Well, let me build the foundation of it a little bit more. According to the dissent, to hear the majority tell it, Roe v. Wade are aberrations. They came from nowhere. They went nowhere. And so it's easy to excise them from the nation's constitutional law. Instead, as the dissent explains, they are rooted in and themselves led to other rights, giving individuals control over their bodies and their most personal and intimate associations. Roe and Casey were from the beginning embedded in core constitutional concepts of individual freedom and equal rights of citizens to shape their own lives. These concepts, the dissent says, might even go so far as defining what it means to be an American. I'll pause here for myself and say that the majority opinion is so clever. It says that abortion is not mentioned in the Constitution. Women are not mentioned in the Constitution. Privacy is not mentioned in the Constitution. This facile notion that words, that terms needed to be mentioned in the Constitution in order to be protected today has no basis except in this concept of originalism that the conservatives used. Television is not mentioned in the Constitution. The internet is not mentioned in the Constitution. Yet there's no question that the First Amendment in the word press grows and adapts to meet new technology so that ever new forms of the press are protected. And the same is true of the terms liberty and equal rights in the Constitution, the Bill of Rights, and the 14th Amendment. And I want to lift up today something the dissent actually doesn't focus on, which is the 9th Amendment to the Constitution. When Robert Bork sought admission to the Supreme Court, he called the 9th Amendment a water blot on the Constitution. Here are these strict constructions who are bound by the original intent of the Constitution, but they're ready to completely ignore one of the 10 amendments to the Constitution. James Madison, when he wrote the Bill of Rights, understood that he could never document and list every right known to human experience. He listed many of them in the Bill of Rights, but he also included the 9th Amendment, which says that the enumeration of rights in this Constitution shall not diminish or disparage other rights retained by the people. It's such an important amendment. Retained by the people. We don't get our rights by government edict. We have our rights by our natural birth as human beings. We created the government. The government is of, by, and for the people. So the conservative majority has it backwards. We create the government. It's the government that has limited authority, while all the rest is left to the people, to our rights. So we didn't need a specific right to be named in the Constitution. And that's what the Constitution says. And the dissent is so good because they turn originalism on its head. They quote the founders as believing that it was a living constitution. It was Chief Justice John Marshall who said in 1819 that this is a constitution that, quote, is intended to endure for ages to come, unquote, and must adapt itself to a future seen dimly. In only 2014, the Supreme Court said that the founders knew they were writing a document designed to apply to ever-changing circumstances over centuries. All of that law is thrown aside by this majority of conservatives. And it was in Casey, when Casey was asked to overturn Roe v. Wade 30 years ago, and a conservative majority of the court would not overturn Roe. As the dissent points out, they did so not only by standing by stare decisis, but by pointing out that the specific practices of the states at the time of the adoption of the 14th Amendment do not mark the outer limits of the substantive sphere of liberty which the 14th Amendment protects. The Constitution is really not a very long document. It has words like due process, equal protection, liberty, cruel and unusual punishment. These terms have to be interpreted. That's supposed to be the job of judges. And even the originalists should abide by the words of John Marshall, and that it's an ever-changing constitution bound by the principles that are embedded in it. And so the court asked in Casey, to hold otherwise would be inconsistent with our law. The court has vindicated the principle over and over that there's a realm of personal liberty which the government cannot enter. The entire, this is me speaking, the entire Constitution protects the right of privacy, even if the word doesn't appear there. The entire Constitution creates a system in which the people enjoy their rights, and the government is limited on how it can interfere with those rights. And those rights include bodily integrity and family life. And case after case has protected those rights and woven those into over 50 years of constitutional history. The majority reassures us that they are not interested in any other right than abortion. They don't want to dismantle any other right than the right of abortion. They promise us that nothing in today's opinion casts doubt on non-abortion precedents. And they do not present an opportunity for those rights to be dismantled. Well, someone needed to check in with Justice Thomas when that broad statement was made by the majority, because Justice Clarence Thomas is very clear. Thomas said we should reconsider all of this court's substantive due process precedents, including Griswold, that's the right to contraception, Lawrence, same-sex intimate relations, and Obergefell, same-sex marriage. And when we reconsider them, according to Justice Thomas, we have a duty, quote, to overrule these demonstrably erroneous decisions. That is the blueprint that Clarence Thomas is laying, and all he needs is 4 more votes for all of that. Now, I, in my article, quoted the legal scholar Samuel L. Jackson. Samuel Jackson tweeted that in listing all the cases that Clarence Thomas wanted to revisit, none of whom included rights protected in 1868, Clarence Thomas didn't mention Loving versus Virginia. It took until 1967 for this court to hold the constitutional right founded in the 14th Amendment of interracial marriage and turning back anti-miscegenation laws. Clarence Thomas is in an interracial marriage, but he didn't suggest that Loving versus Virginia should be revisited. Although the entire logic or illogic of his concurring opinion suggests that Loving versus Virginia is as vulnerable to reversal by this super conservative majority as are those other cases. That is the arrogance, the hypocrisy of this court. That's what lawyers call result-oriented jurisprudence. You have a result. You were, in the case of Kavanaugh, Gorsuch, and Barrett, appointed to this court to do Donald Trump's bidding, and they have delivered on that promise. Now, those justices were only appointed within the last 5 years, and they were sworn under at their confirmation hearings. And they were asked about stare decisis and Roe and Casey. And they looked Congress and the American people in the eye, and they recognized those cases as binding stare decisis precedent within the last 5 years, and within less than that for some of them. The US Constitution provides that federal judges serve only during good behavior. We say they have lifetime terms, but they only serve during, quote, good behavior. I don't think it's good behavior to lie to Congress. I don't think it's good behavior to lie to the American people to get yourself on the Supreme Court so you can do Donald Trump's bidding. And if it is not good behavior, then it's impeachable. And impeachment of those 3 justices, in my view, would be entirely appropriate. Their impeachment and their removal from office for lying under oath on such an important issue as this. The dissent drives home its central point. As a matter of constitutional substance, the majority opinion has all the flaws its method would suggest, because laws in 1868 deprived women of any control over their bodies. The majority approves states doing so today. Because those laws prevented women from charting the course of their own lives, the majority says states can do it again. Because in 1868, the government could tell a pregnant woman, even in the first days of her pregnancy, that she could do nothing but bear a child, it can once more impose those demands. The dissent says today's decision strips women of agency over even the majority agrees is a contested and contestable moral issue. It forces her to carry out the state's will, whatever the circumstances, whatever the harm it will wreak on her and her family. In the 14th Amendment's terms, it takes away her liberty. So, pulling no punches, the Supreme Court said that in overruling Roe and Casey, they did it for one and only one reason: because they have despised these decisions always, and now they have the votes to discard them. the majority, quote, substitutes a rule of judges for the rule of law. Now, the dissent does a further public service because it documents in one place with careful citations to their sources the devastating impact this decision, they said, will, and in the last week is having. They point out the risks of carrying a pregnancy to term dwarf those of having an abortion. Experts estimate that a ban on abortion increases maternal mortality by 21%, with white women facing a 13% increase in maternal mortality than Black women face a 33% increase. This projected racial disparity reflects existing differences in maternal mortality rates for Black and white women. Black women are now 3 to 4 times more likely to die during or after childbirth than white women, often from preventable causes. They go on, and I urge you to find either the dissenting opinion itself. I have circulated my article, which was posted from our friends Dick and Sharon at LA Progressive. You can go to LA Progressive to find my article on this. And I'm very pleased and proud that Ms. Magazine reached out to me. They are publishing online a shorter version of my article to spread this dissenting opinion even wider. I will not catalog the pages and pages of statistics that this dissent puts on the record of the devastating impact this decision will have on women. What they do point out, since the case arose in Mississippi, is the hypocrisy of these states who are so-called pro-life, but turn their backs on helping that life when it does come into being. In Mississippi, 19% of women of reproductive age are uninsured, and 60% of counties lack a single obstetrician gynecologist. 62% of pregnancies in Mississippi are unplanned, yet Mississippi does not require insurance to cover contraceptives and prohibits educators from demonstrating proper contraception use. Mississippi has strict eligibility requirements for Medicare and nutrition assistance, leaving many women and families without basic medical care or enough food. Although 86% of pregnancy-related deaths in the state are due to postpartum complications, Mississippi rejected federal funding to provide a year's worth of Medicare coverage to women after giving birth. And they say in the dissent, perhaps unsurprisingly, health outcomes in Mississippi are abysmal for both women and children. Mississippi has the highest rate of infant mortality in the country. So and those statistics didn't appear in the majority opinion. The majority gave such short shrift to the impact this decision will have on women. The court, the dissent, analyzed the very important doctrine of reliance. Stare decisis is not only important as a theoretical concept, but it looks to how much has a previous precedent been relied on by the American people. the more reliance, the greater the need to preserve precedent, even if you disagree with it in the first instance. That, by the way, was why Justice Roberts did not join in the majority opinion overturning Roe v. Wade. He would have supported the 15-week limitation Mississippi imposed, but he would not overturn Roe v. Wade and Casey because he said, irrespective of how he may have voted 50 and 30 years ago, those are established principles which women and families have come to rely on for half a century, and they should not be cast aside. And that's precisely what the dissenting opinion said. Women have relied on this decision to make life choices about family and pregnancy. They have relied, if contraception fails, to have the option of terminating their pregnancy. And the opinion for several pages that I urge you to read explain in human terms how important that reliance has been and how important those cases have been. So as I come to a close to have time for questions and answers, the final words of the dissent declared that by overturning Roe and Casey, this court betrays its guiding principles. With sorrow for this court, but more for the many millions of American women who have today lost a fundamental constitutional protection, we dissent. That's why this case is so important. That's why within minutes after it, I reached out to my family, to my granddaughter, Lexi, who's a freshman at Vanderbilt College, to her brother, Charlie, to my younger grandsons, to the women in my family, the mothers, grandmothers, to the men in my family who've created families and may create families in the future. And I reached out to them and asked them somehow to stay strong in all of this. Some of you may remember over the past 20 years, and I know this group, I know everyone on this screen, I feel close to you. When I spoke of the Bush years and the trashing of the Constitution in the wake of 9/11 and the increasing erosions on constitutional rights, I would end those talks by mentioning my two, at the time, young grandchildren, Lexi and Charlie. And I imagined the day that Lexi and Charlie would come to me. And I told ICUJP, and I told other audiences that I imagined a day when they asked me, and Lexi created a name for me. She created the name Peepaw. That is my grandfather name that all the grandchildren use now, Peepaw. And I told those audiences that someday Lexi or Charlie could come to me and ask, Peepaw, what did you do back then when those rights were disappearing, when those rights were being violated? And now I imagine Lexi and Charlie and Pete and Hank asking me, what did you do in June of 2022? And in those speeches, I expanded it. And I asked my audiences for the Lexis and Charlies in their lives, with or without children, with or without grandchildren, and for the Lexis and Charlies around the world when it came to the violations of human rights that the US government was engaging in. We all need to ask, what are we doing for the Lexis and Charlies and Petes and Hanks of this world and this country? Justices Breyer, Sotomayor, and Kagan, they've done their job. We owe them a huge debt of gratitude. They created a public document which will last forever, exposing this conservative majority for what it is. And this shameful decision someday, and I hope in my lifetime, and I hope in the lifetimes of everyone on this screen, this case will be overturned, like Dred Scott and Plessy versus Ferguson and Buck v. Bell and Korematsu were overturned. But we can't wait for that day. We've got to do what the labor leaders told us to do. Don't mourn, organize, organize, organize. We've got to pressure the Biden administration to open federal facilities. Any federal land across this country should have medical facilities to allow the constitutional right of abortion to be exercised by the choice of women who want to terminate their pregnancies. We should have federal support for women immediately to travel to states where abortion is legal, here in California and elsewhere. We need the budgets, like the budget of Gavin Newsom, expands funding to allow for women to come to this state to obtain their constitutional right. We need to protect that right through state constitutions that protect privacy expressly in their constitution. If it's not enough for the federal conservative court, then let state constitutions hold the day, as the ACLU is suing in Florida and elsewhere, invoking the state constitution, not the federal constitution. We need to underwrite the cost of abortions for women and largely people of color who cannot afford abortions.
Just in case. It's
and
not.
To have civic, community, business, and religious organizations provide love and support to anyone who chooses to terminate their pregnancy. The courageous and compassionate Justices Sotomayor, Kagan, and Breyer have done their work. We've got to do ours. Thank you very much. I will turn now to questions. I know I went on some time and I appreciate your patience, and I'm looking at the hands and I'll call on people as they raise their hands, and I saw John Crampner first.
Thank you for a very eloquent and heartfelt presentation, Steve. My question is, do you think that it's time for Congress to pass a law repealing the Supreme Court decision in Marbury versus Madison, giving the Supreme Court the right to invalidate laws passed by Congress?
Thank you, John. If all of you heard the question, should we invalidate the power of the Supreme Court to reverse Supreme Court decisions? And my answer is no. A lot of people complain about unelected judges, but there have been so many times we wouldn't have Brown v. Board of Education. We wouldn't have reversed Plessy and these other ignoble decisions. I think the answer is not to limit the power of the Supreme Court. It is to either pass laws and constitutional amendments that put that power beyond the Supreme Court, or to elect presidents that appoint Supreme Court justices that will expand, not contract, supreme constitutional rights. Yeah. I see 5 hands. I'm going to take lots of questions.
Can I just interrupt? For some of the people that are new, on the reactions bar, there's a point where you can raise your hand. That's the easiest way for us to see who wants to ask questions.
And after those, I will try to watch for people waving their hands. I'm going to take lots of questions, perhaps. I'll make some notes, try to gather up my thoughts, but I want to hear from all of you. I'm going to go straight across my screen, Stephen Fisk.
Yes, thank you, Steve, for this extraordinary presentation, and the depths of your presentation is greatly appreciated. And I just want to say on a personal note that you can stand before your grandchildren in the depths of your response to this, and the articles that you've written and so forth and so on. And I know that this effort will continue on your part, and you can stand before your grandchildren in the pride of your response to this Supreme Court hypocrisy. So in regards to that hypocrisy, how do we proceed in what are the realities of impeachment or recall of these judges?
Thank you. I'll make a note of that. Carol Francis.
Hi. Thank you. I mean, I was just really blown away. The whole anti-abortion movement is based on that's murdering a human being. But your statistic you gave of women, especially women of color, dying because of lack of abortion just really shows that. And, you know, it's clear that they feel that life begins at the moment of conception and ends at birth. I'm wondering if we can conceive, though, of the possibility in maybe with a different economic system where wealth does not control how people vote, if we could actually one day have some sort of revolution where we actually, as a people, look at our Constitution and totally rewrite it totally keep all the things that we like, but throw out everything we don't, and have plebiscites where people discuss each part. And in Cuba, they've had 2 new constitutions since the revolution, and the first one in the 70s recognized the right to eat and the right to have a roof over your head. The one about 4 years ago bans discrimination based on gender, race, ethnic origin, sexual orientation, gender identity, or disability.
Yes.
It also recognizes that climate change is a threat. This is a constitution that the people debated. Over 100,000 people, debates on these, taking them apart, and the turnout for voting on them was in the 80%, and the vote was in the 90%. So in our system under capitalism, where elections are won because of billions of dollars put into it, it wouldn't work. But if we could throw out capitalism, that we should come back next week.
Thank you, Carol Francis. Michael Novak.
Yes, thanks. I appreciate, let me lower my hand too, what you put forward. I had a couple of thoughts I wanted to share. One is I think we should stop calling them conservatives. They're reactionaries. I think it gives them too much credit. I do think also that, I appreciate what you said at the end about what did we do, because I think that actually the blame and the responsibility is on us. I think that, when the Powell memorandum came out after Lewis Powell was appointed to the Supreme Court about his concerted plan with the U.S. Chamber of Commerce to reassert corporate control and reverse all the gains of the 60s, that, it was on us to rise up against that. Bush v. Gore, which imposed, George W. Bush as the president of the United States against the will of the majority of the people who voted. If that had happened in the Philippines, there would have been tanks in the streets. Even in France, there would have been massive uprising, and civil dissent. And here, people said, "Oh, our long national nightmare is over," because the Supreme Court settled the confusion about who was elected. So, I just think that even in terms of the reversal of rights, people accepted the overturning of the Voting Rights Act by the Supreme Court. And, whether you think there's a constitutional right to vote, because voting is not mentioned in the Constitution either, as an individual right. So I agree with what Carol Francis said. Even in capitalist countries, they have written new constitutions. Chile threw out the Pinochet constitution and adopted a new constitution. Spain, after Franco, adopted a new constitution. Even if we're not prepared to have a socialist revolution in this country, I think it's possible to imagine a different form of government than we have. Most of the Western democracies that are capitalistic actually have parliamentary systems. I think we need to expand, our concept of what we're dealing with here. I'll leave it at that.
Thank you. Paul?
Yes, thank you so much, Steve. Outstanding dissertation that you've given, and I echo everything that Stephen Longfellow-Fisk has said. And I think that Lexi and Charlie are already incredibly proud of PIPA, and I think I'm so glad that this is being recorded, not just for my sake to go back and rewatch and share with other people, but for their sake, because it's been a historical talk that you've given today at ICUJP. My question very much as a non-citizen. You mentioned that had Hillary Clinton been elected president, it would have been a very different situation. Yes, it would in her choice, but not in the way that the game is played. And I think that maybe the question is how the situation is set up, whereby the president in office can make this choice. It seems to come down almost to being the luck of the draw. And perhaps that the luck of the draw is not in the best, clearly is not in the best interest, or seemingly not in the best interest of the people of the United States.
Thank you, Paul. And I'll have comments as time allows. Ruby? be sure to go off mute.
Yes, powerful. It's just powerful. I mean, you went from the schools, and I remember schools when I had my children in Catholic school and everything. And that was when I learned that everybody was okay. Everybody the same. You know, that all religions were from the same God, you know. And so I think it's really, you know, and you went over the different areas, which was so good. That this is something that we need to keep, we need to promote, and we need to put out, because it's not just over the one thing, it's over women as humans. And the other thing I think is working to change that abortion is not a bad word, it's a medical word and a medical determination. And then our next step is important. What we set up as the group, because we have ministers, we have doctors, we have lawyers, we have people that are just people, you know, we have seniors, we have everything. So people that would be basically interested in seeing what our next step is when we go from here, because this is what we're about. Thank you. And thank you, Steve. Thank you so much.
You're so welcome. Thank you. Brief questions with our limited time. Dave.
Yes, Steve, what are the possibilities for improving, changing this situation in terms of expanding the court to 11 members, which would still give the reactionary majority 5 to 4, or 13, which could give the humane portion of the court a 6 to 5 majority. That's my question, and thank you.
Good. Thank you, Rick, and then Karen.
Thank you for doing this talk. One thing that struck me from the comments of other people is, and I'm going to just have to say it the way that it reflects for me, that I think we're putting a lot of hope on folks to be involved in changing the court by voting, and I don't think that people are paying attention enough right now. We have people that probably have not opened a newspaper in years that are getting their political opinions from 10-second sound bites and bumper stickers, and that's the depth of what their analysis is. And I think that's what we need to fight. I think that our ability to be able to make change starts from the smallest offices that people can vote for and run for. If we're not making those changes in school districts, then your kids are always going to learn to test and not, and that's why we don't have civics classes anymore. So I think that's something that's something for us to keep in mind as we look at solutions.
Thank you. Karen and Anthony.
First of all, I want to say thank you so much. I learned a huge amount, and not only was it informative, educational, but so inspirational. And I know several people in my family that I want to send the recording to, but I started wondering if you know people who do podcasts, because it would make a perfect podcast, and so many young people in particular listen to podcasts. I was going to ask the same question that Dave did about expanding the Supreme Court, and so I won't ask it again. I don't hold out a lot of faith that the federal government will establish clinics on federal land. but yeah, just, open to other suggestions that you have for organizing. Thank you so much.
Thank you, Karen. I'm so glad you joined us today. Anthony.
Well, Steve, I just can't thank you enough for your presentation. It was so powerful and enlightening. And I'm glad it's also in writing. And I posted the link to the LA Progressive article. One point you made is about Hillary Clinton. And of course, we all know that she was elected president by majority of the Americans, by almost 3 million votes more than Trump. And yet, someone who was elected, who did not receive a plurality of popular votes, became our president, will influence our country for decades to come. There's something profoundly flawed in the electoral college system that needs to be changed. And also to keep in mind that what happened has been planned by conservatives for decades. They've played the long game. Their plan is not just to influence a few legislation, few policies. Their plan was and is to rig the system, to make it impossible to have progressive legislation. And they have really been quite successful. So we need to have a long game too. And I have to go, I have a meeting at 9:30, but I hope we can have a discussion about what is the long game that progressives need to play to transform our system so it really represents what the people of our country want, because now a minority are controlling our system, and that needs to change. So thanks again, Stephen. Thank all of you. I'm sorry I have to leave for another meeting, but I really appreciate it.
It's good that you're leaving, Anthony. It means you're doing the work that we all need to do.
Okay.
So I understand.
Okay.
Look,
Thank you.
Thank you, Anthony. And folks, look, thank you very much for your kind words as well as your insightful questions. Let me just say a few things. First of all, no article, no speech can cover everything. I believe the Electoral College should be eliminated. I believe I should have mentioned it as one of the most undemocratic portions of the Constitution from its very origins. Expanding the court. The Constitution does not say that the court shall have 9 members. It doesn't mention the number. The Supreme Court has gone from 11 to 10 to 9 to 7, I believe. It's been all over the board. It's within the power of Congress. I only want to say in this regard and some others, be careful what you wish for, because if the Senate and were in the grip of a super conservative majority and a reactionary majority, and a reactionary president was elected, and there was a 13-member Supreme Court, we could get 10 reactionary justices just by the strike of an expansion bill. So I think we got to think very carefully about the question of expanding the court. I'm trying to research it, and I'm just concerned about those issues. Likewise, calling a new constitutional convention could be dangerous because then any amendments could be brought forth. People wanted an amendment making flag burning unconstitutional. So at every step, you have to think about the unintended consequences often. If we could revolutionize our Constitution to protect and emblazon these individual rights in the very text of the Constitution in a way that we could achieve that, I would support that. I do think that impeachment is real, but you've seen even in the best of circumstances with impeachment of Trump twice, it all depends on politics. It depends on 2/3 of the US Senate voting to remove from office and convict. So it really comes back. I apologize if I didn't mention every question that was raised. Bush v. Gore needs to be added to the list. Shelby was the case of cutting back voting rights. And I think it was Anthony that pointed out that this is the march of a hard right Christian nationalist movement in this well-funded corporate movement in this country that is coming to fruition. And so I end with almost a simple and true to the spirit of ICUJP comment, which is for now in this Constitution, in this political system that we live under in 2022 and going to 2024, we have to get out the vote. We have to get people off their couches. We have to use the anger of the reversal of Roe v. Wade to ensure that every young person qualified of age to vote in this country is registered to vote and votes in state elections, state legislatures, Congress, the Senate, and 2 years from now in the White House. We have those votes. We have majorities that elected Gore and elected Hillary Clinton. We've got to exercise the muscle and the long game, as Anthony said. I'm just going to close. We're over time. I'll be turning it back to Rick for our closing circle and a closing prayer. I just want to thank every one of you. It has been so meaningful for me for these 21 years to be part of this group. We've got to maintain our tenacity. We've got to maintain our hope. And we've got to maintain our vigilance. The worst realities that we predicted over the course of those 20 years is coming to fruition. ICUJP has never been more important, and your support of us in coming to these meetings and joining our program in September is vital. Thank you so much, everybody.
Thank you.
Steve, I think I can speak for pretty much everybody here. Thank you very much for your insights, and as in the next coming weeks, you guys will see on YouTube channels this presentation. I implore you to send it out to your friends, because this is how we spread the news. This is how we get people to think. So I appreciate if you can do that.